Salutations, all. The House Committee on Oversight and Government Reform has the power to conduct this deposition of Dr. Kevin O'Connor in accordance with House Rule 10 and the rules of the Committee on Oversight and Government Reform. As a result, the committee has wide authority to investigate any subject at any time per House Rule 10. Chairwoman Comer asked Dr. O'Connor to participate in a voluntary interview on May 22, 2025. As part of the committee's probe into President Biden's purported deterioration in mental and physical health and the White House's attempts to conceal this from the American people through unlawful executive acts. Alterations to the Constitution's 25th Amendment are among the legislative options being considered by the committee to resolve these challenges. I will include Chairman Comer's initial request as the first exhibit. Legal representation for Dr. O'Connor provided a response to the Oversight Committee on June 4. Counsel informed the committee in writing that Dr. O'Connor would be unable to make it for the scheduled interview. This will be submitted as Exhibit 2. Dr. O'Connor was summoned to appear before Chairman Comer for this deposition by subpoena dated June 5. Several privilege issues made by Dr. O'Connor's legal team were addressed by the committee in that cover letter. After reviewing Dr. O'Connor's legal arguments, the committee informed him that they were all without merit. The subpoena and cover letter sent to Dr. O'Connor are attached as Exhibit 3. The committee took note of the deposition that took place today, July 3, 2025. The notification for this deposition will be entered as Exhibit 4. I will also present the notification of a change of room, which leads us to our current location, as Exhibit number 4. For the sake of accuracy, would the witness mind spelling out his last name? Kevin O'Connor, MD. CN Noir is an apostrophe. I appreciate it. I am Jake Greenberg, and Chairman James Comer appointed me Chief Counsel for Investigations. You are permitted to have legal representation present to advise you during this deposition per the regulations set forth by the Committee on Oversight and Government Reform. Present today are attorneys who are acting in your individual capacity. Indeed, he does. The attorneys present should formally present themselves for the sake of the record. Scherbler, David. Mark, my dear. Just so we're all on the same page, might the supplementary staff members kindly identify themselves by name, position, and affiliation, beginning with the majority staff? Mitch Benzine, the majority's general counsel. One of the majority's senior advisors is Margaret Harker. The bulk of my department's professional staff is headed by Mark Morin, who is also the staff director for Peter Spector. Those not in the majority. Excuse me. Melman Soto, who is the minority group's general director. Also included are the minority. Additionally, Mr. Comer, James Comer, and the person from Kentucky can be linked. Yes, those two are summer associates, Zoe Osborne and Carolyn Caitlin. Many thanks to everyone. We appreciate your flexibility. Sure thing. Dr. O'Connor, I'd like to review the rules of engagement for this deposition before we start. The rules for the use of deposition authority issued by the House of Representatives, which were provided to your counsel, will be followed by the committee during today's deposition. The Committee on Oversight and Government Reform rules, which were also provided to your counsel, incorporate this regulation at Rule 15. Rounds of questioning will be conducted. After the majority has had an hour to ask questions, the minority can do the same if they so want. During each round, a staff counsel from each side will ask the questions. Members will have the opportunity to ask the witness any questions they may have during their side's round. Is that clear to you? Following legal counsel's recommendation, I will politely decline to comment, citing my right to remain silent under the Fifth Amendment and the physician-patient privilege. I need to listen to my lawyer's counsel on this as I am not an attorney. Regarding any questions that may be posed at this deposition, we intend to assert both privileges, gentlemen. And there's no getting Dr. O'Connor to talk. We can leave now. Okay, Dr. O'Connor? Once again getting down to business. While your counsel is speaking and members or staff of the opposing side are speaking during their rounds of questions, the clock will stop if the witness needs to confer with counsel. Until everyone has asked their question, we will switch roles. Is that clear to you? According to my legal advisors, I am using my Fifth Amendment right and politely declining to answer any questions. I'm not an attorney. My lawyer has advised me to do this, and I must do it. A court reporter is taking notes during the deposition so we can both have our words documented. For the sake of clarity, before you start answering a question, please wait for the person conducting the interview to finish asking it. The interviewer will also wait for you to finish answering before moving on to the next question. Additionally, talk slowly, clearly, and concisely so the court reporter can accurately record this deposition. In addition, the court reporter is unable to capture expressions like nodding or shaking the head when you respond. Therefore, make sure you vocally respond to each inquiry. Is that clear to you? Following the counsel's recommendation, I will politely decline to answer, citing my right to remain silent under the Fifth Amendment. I need to listen to my lawyer's counsel on this as I am not an attorney. The record can be updated to include exhibits. Numbers will be used to identify most exhibits. There will be an alphabetical listing of minority displays. We want you to answer our questions in the most thorough and genuine manner possible, so we will take our time. If you have any issues or do not fully understand the question, please let us know, and we will strive to clarify, give context to, or rewrite our inquiries. If we inquire about specific discussions or occurrences in the past and you are unable to recall the exact words or specifics, you should testify to the substance of such conversations or events to the best of your recollection. If you recall only a part of a discussion or incident, you should tell us your best recollection of those events or sections of conversations that you do recall. If Congress asks you a question, you must answer honestly. The questions asked by members of Congress during this deposition fall under the same category. Is that clear to you? After consulting with legal counsel, I have decided to politely decline to answer, citing my right under the Fifth Amendment. My background is not in law. My lawyer has advised me to do this, and I must do it. False statements, whether made intentionally or not, can lead to criminal charges such as perjury. Is that clear to you? I have been advised by my legal advisors that it is my right under the Fifth Amendment to politely decline to answer. My background is not in law. My lawyer has advised me to do this, and I must do it. For the record, would you kindly identify yourself, ma'am? Congresswoman Jasmine Crockett, Texas 30. You can't give partial truths or leave out details that are critical to proving your points. In order for your response to be considered truthful, you must include all relevant details. Perjury or a false statement can result from the willful concealment of information. Is that clear to you? As counsel, I am your best bet. In accordance with my right under the Fifth Amendment of the Constitution, I respectfully do not wish to respond. I need to listen to my lawyer's counsel on this as I am not an attorney. In today's deposition, is there any reason you can't tell the truth? Following legal counsel's recommendation, I will politely decline to answer, exercising my right under the Fifth Amendment. I need to listen to my lawyer's counsel on this as I am not an attorney. This deposition is not subject to the federal standards of evidence that govern civil and criminal procedure. The House deposition rules provide that a witness's counsel cannot advise their client to decline to answer any question unless doing so would protect a privilege. Make sure your privilege assertion follows the guidelines of the Committee on Oversight and Government Reform if you want to make one today. Committee Rule 16C1 specifies that, prior to the scheduled date of testimony or appearance, the chair must clearly state the specific privilege being asserted and the reason for the assertion in order to consider assertions of privilege over testimony or statements, witnesses, or entities. A letter dated July 8, 2025, from Gary Lakowski, Deputy Counsel to the President, to your counsel informs you that President Trump has decided not to assert executive privilege over matters pertaining to your evaluation of President Biden's fitness for office and your financial connection with the Biden family. This letter will be entered as Exhibit 5. Any objections raised during the deposition must be brief and not argue or indicate anything. The committee may ask the chair for a ruling if the witness is trying to maintain a privilege by refusing to answer questions. In the event that the chair decides to disregard the objection, the witness will be summoned to answer. Is that clear to you? Relying on my right under the Fifth Amendment of the Constitution, I must politely decline to answer, as advised by the counsel. My background is not in law. In this issue, I am obligated to adhere to the counsel of my attorney. Sanctions may be imposed on witnesses who persistently refuse to answer questions even after being told to do so. Is that clear to you? After consulting with legal counsel, I respectfully decline to answer the reliance question in accordance with my Fifth Amendment rights. I need to listen to my lawyer's counsel on this as I am not an attorney. As a last point, I'd want to remind everyone here that the House deposition regulations guarantee the secrecy of all testimony. Prior to the publishing of any testimony, transcript, or portion thereof, the rules require consultation between the chairman and ranking minority members. The contents of this deposition cannot be revealed before its official release, since this would be in breach of both House and committee rules. Would you mind taking the witness's oath of office, reporter? Are you here today to solemnly swear, under oath or affirmation, that your testimony is going to be truthful, and nothing but the truth? Yes, I appreciate it. The record will not be used. Did anyone ever tell you, Dr. O'Connor, to mislead the public about the president's health? I respectfully decline to answer based on physician-patient privilege and my right under the Fifth Amendment of the Constitution, as advised by my lawyers. My background is not in law. My lawyer has advised me to do this, and I must do it. It should be noted that Dr. O'Connor has used her protection against self-incrimination under the Fifth Amendment. Please, Dr. O'Connor, be explicit. Do you really think that answering this question will bring charges against you, thus you are choosing not to answer it? After consulting with legal counsel, I respectfully decline to answer because I am exercising my right under the Fifth Amendment and the physician-patient privilege. Since I lack legal training, I will have to follow my lawyer's recommendations about this issue. Did you ever think the president lacked the qualifications to carry out his responsibilities as president, Dr. O'Connor? Based on the counsel's recommendation and my right under the Fifth Amendment, I respectfully decline to answer due to the physician-patient privilege. I need to listen to my lawyer's counsel on this as I am not an attorney. Please note that Dr. O'Connor has used her right to remain silent by invoking the Fifth Amendment. Good day, Dr. O'Connor. Could you kindly clarify if you are refusing to answer a question because you are afraid it may implicate you? Respectfully, I must decline to answer in accordance with the physician-patient privilege, my right under the Fifth Amendment, and the Constitution, as advised by my attorney. My background is not in law. My lawyer has advised me to do this, and I must do it. Dr. O'Connor, will you be using your Fifth Amendment protection against self-incrimination to refuse to answer any and all questions posed to you today by the committee? After consulting with legal counsel, I respectfully decline to answer because I am exercising my right under the Fifth Amendment and the physician-patient privilege. Since I lack legal training, I need to listen to my lawyer's counsel on this issue. Also, rest assured that he will provide consistent responses to any inquiries made. Much obliged, sir. Would someone from the minority like to pose a question? Something that we would like to provide. We'll keep this private. Dear Dr. O'Connor, pleasant morning. For the record, I wanted to mention that before you came for today's deposition, your lawyers brought up the fact that the questions asked of you by my colleagues in the majority may force you to violate doctor-patient confidentiality, a basic principle of medicine that has been around for a long time and is well known and respected, as your lawyers have explained. In addition, your lawyers have informed the majority that you risk breaking your ethical and legal duties to your patient and facing serious professional and personal repercussions if you answer any questions they have today that compromise doctor-patient confidentiality. I believe you had a statement you wanted to make for the record, Mr. Schertler, and I'd like to give you that chance now. It is really appreciated. Thank you, Chairman Comer and Representative Crockett, as well as staff members from the majority and minority groups. Good morning. Here at Schertler and McDougall, we represent Dr. Kevin O'Connor. My name is David, and I work alongside Mark. Everyone knows that from January 20th, 2021 to January 25th, 2025, Dr. O'Connor was President Biden's physician. For 12 years prior to President Biden's inauguration in January, Dr. O'Connor served as both his primary care physician and the head of the White House Medical Unit. This was an honor and a privilege for Dr. O'Connor. For 20 years, Dr. O'Connor was an active duty soldier in the U.S. Army, serving in both Afghanistan and Iraq. The committee has made it clear to Dr. O'Connor and his legal team that it has no intention of upholding the physician-patient privilege, a widely recognized legal right. On the contrary, we have learned from the committee that it intends to insist that Dr. O'Connor divulge all secret material pertaining to President Biden's medical exams, treatments, and care. There is no more basic ethical obligation for a doctor than to keep their patients' private information private. Dr. O'Connor may face legal liability in the suspension or revocation of his medical license as a consequence of this. No patient, not even President Biden, will ever have their privacy violated by Dr. O'Connor. In addition, on June 4, 2025, President Trump issued a presidential memorandum instructing the Department of Justice and the White House counsel to launch a concurrent criminal investigation into the same subjects under scrutiny by this committee. Actually, I think you verified on Fox News last Sunday that Pam Bondi has announced an inquiry of the Department of Justice investigating the improper use of the auto pen, Chairman Comer. Dr. O'Connor has been left with no choice but to refuse to answer questions on two overlapping grounds due to the totality of the circumstances surrounding this committee's investigation. We believe the committee should hold its investigation in advance until any criminal investigation has been conducted. Dr. O'Connor refused to testify regarding his care and treatment of President Biden for several reasons, including the physician-patient privilege and the ethical obligation of secrecy. Secondly, Dr. O'Connor is compelled to exercise his constitutional right to the Fifth Amendment in response to any questions that the committee may bring during this deposition due to an ongoing criminal investigation by the Department of Justice. Furthermore, we would want to stress that Dr. O'Connor has not committed any criminal by claiming the Fifth Amendment. In fact, to the contrary, our Supreme Court has emphasized, and I quote, "One of the Fifth Amendment's basic functions is to protect innocent men who otherwise might be ensnared by ambiguous circumstances." End of quote. For these reasons, Dr. O'Connor will respectfully decline to answer any questions that might be posed to him by the committee today. Thank you. Thank you, sir. I'm also going to ask the court reporter to mark as Exhibit 6 a presidential memorandum White House, dated June 4, 2025, which, among other things, directs the counsel to the President in consultation with the Attorney General, along with head of any other relevant executive department or agency, to investigate, to the extent permitted by law, the allegations that the majority has leveled in this matter. I'm also going to ask that the reporters mark as Exhibit 7 a letter dated July 5, 2025 from Dr. O'Connor's counsel to Chairman Comer as well as the ranking members setting forth their position as to the relevance and applicability of the doctor-patient privilege to the proceedings today. Go. Conrad. Thank you, Dr. O'Connor. Considering your invocation of the Fifth Amendment pursuant to the terms of the subpoena, you are excused.